Thank you for your comments. I really appreciated them. As I listen to you, though, in my estimation of what you're saying, there are more than constitutional problems. There are logistical problems. For example, in your view, would the statements obtained from a third party who was subjected to cruel and inhumane or torturous interrogation be admissible? And then there's no way to challenge the reliability of that if it's received ex parte under seal. So there are logistical issues that I didn't hear you address. And the other really comes from our work in Ireland in the counterproductive effects of a separate court that would inevitably, in the conflict that we're engaged in, have defendants who fit particular categories, and therefore the targeted communities would feel that the system was being illegitimized in some ways, and therefore it would result in less cooperation by those communities, perhaps as happened in Northern Ireland, in gaining information from people who have that most access to it. So they became wary of the system and didn't participate in it, and kind of closed ranks because they felt they were being taken out of what is viewed by most people as one of the best judicial systems that's in place in the world today. And by taking away the protections that have protected people in our country for centuries, it seems to me that you're likely to end up with a system that is counterproductive to what the goal is. And I agree with you, we've got to find some way. And I think we have to start working before the next 9/11, because waiting till it happens, we don't end up with the best policies we see.
All right, 3 questions, right? Answer number 1. When you call it logistical, I think I would call it constitutional, but maybe it's the logistics of the Constitution or the Constitution of the logistics. Information implication, or somebody who's been implicated by somebody else, if that individual testified, or in the course of his interrogation, he was tortured, then I would say that his testimony, his interrogation, cannot be submitted into a court of law. So the fact that the detainee, he himself was not tortured, but the person who implicates him was, that statement cannot be submitted into a court of law. And here I can only quote my very good friend, Colonel Mo Davis, who has been the chief military prosecutor in Guantanamo, who stated, I think it was 3 years ago, that if forced to submit evidence that had been illegally gained, he will resign his position. Ultimately, Mo resigns. Couldn't agree with him more. If somebody is implicated based on torture, it's inadmissible. With respect to what you call the targeted community, I think you can look at this from 2 different perspectives. One, it establishes a separate category. Problematic, maybe, but on the other hand, it establishes a procedure which, as I suggest, is predicated on the Constitution, with that one difference, with that one exception about the right to confront. And I think most importantly of all, it begins the process of enabling the bringing to trial of individuals who are simply being held 7 years later in this legal limbo. And I would think that from their perspective, the beginning of a trial and going forth with the legal process with civilian judges, not military judges, with a lawyer of their choice, open court, I think is far preferable to the status where they are now being held. Does that have the possibility, the potential to blow back? You know, anybody who's been involved in operational counterterrorism, such as I have, knows there's always the possibility for blowback. It's inherent to the process. But I would suggest that establishing a judicial process that we can begin the trying of individuals is far more effective long-term than where we are today.
Hi.
How you welcome?
A couple of things. You spoke about people having rights, and yet you base these courts to a large extent on hearings on administrative detention in the occupied Palestinian.
And just a part of, I use that only as an example of the process of the introduction of the classified information where there's no defense attorney present. I use that as an example of how the process could work with respect to the introduction of the classified information. The criminal law aspect of my domestic terror court is just like the criminal law process, you know, in TV shows Law and Order, where you can see on TV regularly. So that's just, it's a piece of the puzzle.
Okay, but that piece, administrative detentions in the occupied territories, tens and tens of thousands of Palestinians spent months and years this system has been called unlawful under human rights law by the Human Rights Committee of the UN, and the Committee Against Torture has even classified it as cruel, inhuman, or degrading treatment. So I don't think it's a very good source for anything. I don't quite understand the classification of people posing a threat to the US. Some people may have committed atrocious crimes but no longer pose a threat. Would they be released? And what kind of a crime would they be accused of?
Right.
The crime of posing a threat seems a bit tricky.
No, it's not the crime of posing a threat. It was based on the vetting process. I mean, you make an important point here, Yuval. One of the things that's been lacking in this entire debate is the articulation of who presents a threat. There's not a crime of presenting a threat, but only once we know that the intelligence information that we have with respect to that person is viable, valid, reliable, and corroborated, and suggesting the individual's possible involvement in future terrorist attacks, he's the one or she's the one who would fall into my category of someone who would be brought before a domestic terror court based on obviously things they've done in the past, not for the crime of a threat, but only through the intelligence information would be able to discern whether or not they present a threat. Joe, yeah, George.
This idea that we could have some kind of a super summary process and get things done quickly. This has been a recurrent suggestion for many years, but I want to call to your attention a very important paragraph in the Al-Mahdi opinion, which I think is one of the best written opinions in this whole area, where the Fourth Circuit makes it clear the basic rule is criminal prosecution. There are some limited exceptions to this. Juvenile cases, right? Psychotic offenders, citing the Hendricks case. That's it, right? So you're working within a constitutional structure that is far more convincing than the particular alleged needs of the moment. And the only argument that I heard you make was a cost-benefit argument. But I'm sorry, cost-benefit is not a constitutional argument. No one ever suggested that the Bill of Rights was based upon, I mean, maybe some economists have argued this recently, but to defend the Bill of Rights. No one has ever argued that if you have a cost-benefit argument contrary to the Fifth Amendment, the Sixth Amendment, the Fourth Amendment, that somehow your argument prevails. So if you want to take this idea seriously, I think that you have to develop some kind of serious arguments. And in the military commission line of thought, at least there is a historical argument. You don't have that. You don't even have a historical argument. And you want to break from the historical precedent and say, I want something new that is supposed to be good just because it is efficient.
No, I think it's more than that, George. We're going to disagree, which is fine. I think that we need to establish a process, key word here, that enables us to go forward constitutionally in order to bring people to trial who otherwise are not going to be brought to trial. We can disagree maybe as to the logistics, as to the question here, but to continue as is clearly a violation of the Constitution. And I think that not to begin the process of asking ourselves what is a judicial alternative is simply to put our hands or keep our heads in the sand. And I don't think that's a viable option whatsoever.